Sierra Coke on behalf of the people.
James Dick on behalf of Mr. Barto.
Thank you. The record should reflect Mr. Barto is present here in the courtroom today. This is the date and time set for sentencing in this matter. Mr. Barto, did you have a chance to review the pre-sentence report and go through that with me? I did. Mr. Dick, are there any additions, deletions, or corrections to that report?
I'm going to say there are not, but I just realized you said Jane. His name is Jamie.
Jamie.
It appears to be correct on the report. On the PSI.
Yeah. Okay.
So there are no additions, deletions, or corrections, Your Honor.
Okay. Ms. Coke, do you have any corrections to the report?
No, Your Honor.
Anything on behalf of the people for evaluation today?
Your Honor, I think the recommendation is appropriate. I hope that he takes advantage of the 7411. We know as a court that people get offered this a lot, and a lot of them are not successful in it, and it can change their life pretty dramatically. Mr. Barto has never been on my radar and has popped up a couple of times now. He only has one prior misdemeanor, and it's, it looks like it's a traffic offense. And then he had a couple of things that were dismissed. I would ask the court to follow the recommendation. Thank you.
Thank you. Mr. Dick, anything on behalf of your client today?
Likewise, we would ask that the court adopts the recommendation. Mr. Barto, he has been essentially a stay-at-home, soon-to-be step-parent to his fiance's child while she's able to work. Saves them somewhere between $400 and $500 a week in childcare. He was a tradesman, generally worked on bridges and highways. However, the circumstances that he's currently in suggested that, or made him believe, and his fiance believe, that it would be best for him to tend to the child rather than go out and seek additional employment and try to make up the difference in the money. So with that, Your Honor, Mr. Barto, he doesn't have a significant criminal history. And it's my belief that he will, in fact, adhere to the terms of probation, and he will successfully the 7411. We just ask that the court takes into consideration the familial employment status as fines and costs are assessed in this matter.
Thank you. Mr. Barto, anything that you wanted to say today?
No, just that I made a terrible mistake, and I'm going to do everything I can to make it right again.
All right. I did read through the report, so I'm familiar with the circumstances here. There's a lot of information in that report about yourself and your background as well. Take all of that into consideration, including what the lawyers had to say here and yourself as well. I think probation under 7411 is an appropriate resolution of this matter. I think it's going to give you an opportunity to have this come off of your record if you successfully complete the probation. There's really no downside to the community. If you're able to complete your probation successfully, it's good for everybody. And if you're not, then we'll be back here to figure out where we go from there. Your lack of any serious prior history, again, I think also direct support towards the probationary period, again, pursuant to 7411. The circumstances of the crime itself, where you had a small amount, looks to me from what I read like a personal use amount. It doesn't look like you were distributing or selling, or dealing with large amounts. That's not to say that this is a good thing or it's healthy for you, particularly if you're going to be caring for a child. You need to be in your right mind, so you need to not expose that child to those kinds of substances, which are very dangerous. So personal use amounts or not, that's something that around you at all. And of course, Court is going to follow the recommendation and sentence you to probation for a period of 1 year pursuant to 7411. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. I think under the circumstances, an initial term of jail is necessary, but you need to understand that if you violate your probation, it's something that will be on the table. Your family's financial situation or your need to care for that child will not be a consideration. Because at that point, if you violate your probation, it'll be apparent to me that that was less important than doing other things to you. And so then there's no reason for me to put more importance on it than you have yourself. So I just want to caution you, and I hope that that's an added motivation to you to comply. The court is going to impose a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $50 state costs, and a supervision fee of $30 per month while you're on probation. Some of those fines and costs I can't do anything about. I'm required to impose by statute. Some things like court costs or attorney fees, you can do community service, things like that, rather than paying those. So that's something you can talk to the probation agent about in terms of how to avoid the financial hardship of those by doing other things to make up for that. Because this is pursuant to 7411, there is no appellate rights. Mr. McDowell, are you going to meet with Mr. Barto here?
Yes, I am.
Okay, so just touch base with Mr. McDowell before you leave, and you'll let me go.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Vernon, were you ready with Mr. Law's case?
Yeah, Your Honor.
People versus David Law, file number 255382. The record should reflect Mr. Law is present here in the courtroom today. If I can have counsel.
Spirit Coke on behalf of the people.
Ken Byrne on behalf of Mr. David Loud, who's present standing to my right.
This is the date and time set for sentencing in this matter. Mr. Law, have you had a chance to go through?
Yes, Your Honor.
Mr. Vernon, are there any additions, deletions, or corrections?
The only addition I would say is that I was made aware of a letter from the victim, Amanda Hall, this morning. I don't know if that has been added to the report or not.
As not, and I should read that. Oh, wait. Get that. I didn't have a chance to read it, so let's take a look at that. Okay, I did have a chance to read that letter. Did you want that attached to the PSI?
Yes.
Any other additions, deletions, or corrections?
No.
Any challenges to the scoring?
No.
Ms. Coke, do the people have any additions, deletions, or corrections?
No, Your Honor.
Does Ms. Hall wish to address the court today to your knowledge, other than the letter?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, when I looked at my notes in my last domestic violence case with Mr. Law, I read almost exactly the same thing from Ms. Hall a year ago. She didn't want any of this to happen. She didn't want him violated. He was hurt by her actions. Frankly, Mr. Law had almost no criminal history. I think he had an impaired driving in 2015, and then the domestic violence in 2024. Had a couple other misdemeanors. Somebody that goes from that type of criminal history to what we had in this circumstance, usually we see somebody who has a much longer history. You know, he's only 34 years old. We gave him what I thought was a very fair plea offer. I think the recommendation is appropriate. I hope that Mr. Law learns from his actions and that we don't see him again. Thank you.
Thank you, Mr. Vernon.
Your Honor, the guidelines here are 7 to 23, the recommendations for 11 months. We're asking the court to consider something at the low end of the guidelines. We're asking the court specifically to impose the 7 months. Mr. Law has acknowledged that his actions here were a series of poor choices. I think the underlying or overriding focus for Mr. Law has been trying to maintain a relationship with his children. He's made poor choices in an attempt to do that, violating the court's order and engaging in this behavior clearly is part of that. Consistent with the letter that we have from Ms. Hall, she is a strong support system for him so that when he gets into a situation where he's confused and he wants some input and some advice, he often goes to her, leading to this causing even more stress and problems and concerns and anger on his part because he's not sure who he's supposed to go to talk to assist him with making decisions. So I acknowledge, and I think he acknowledges that the focus here has to be on co-parenting and whether any further relationship develops with Ms. Hall, is not the focus. The focus is on managing the children in an appropriate way, having a good relationship with Amanda as a co-parent, not necessarily as a significant other. I think he understands that based on my conversations with him. His goal here is just that, to address these, to come up with sufficient tools and other community resources, personal resources, support system, so that when he has concerns and questions and he's not sure what to do, that he has the appropriate people to talk to and address those issues. So he doesn't end up doing things that are in violation of court orders or that are scaring people. And I think he understands that. I think that there are some services in place here under the terms of probation that will assist him with that. So we would ask the court to consider the low end of the guidelines, where the focus here has to be on providing him with additional tools and not necessarily on punishment.
Thank you, Mr. Law.
Yes, Your Honor. I just want to make this perfectly clear that you'll never see me again. I just want to focus on my children and not necessarily Amanda, just developing a good co-parenting and just making better choices for her and I, for our children. Because they are going to be impacted, not seeing the father, and they have been impacted this whole year, not being able to see me as much as I was before I lived with them. No father should have to go a day without seeing their children. And I've gone many days, and it's hard. So that's it.
I did read through the report. I'm familiar with what happened in this case. I presided over a number of different hearings with you, so I'm familiar kind of with the circumstances generally and how things have gone for the past year or so. So I'm really familiar with the facts here. I take all of that into consideration. I've heard what the attorneys had to say. I've read the background information in the report about you and your circumstances generally. I read Ms. Hall's letter here, of course, just now. And it does seem like things have really gone awry for you recently, and that generally there hasn't been issues. You don't have any kind of serious prior history. So what that tells me is, there was a problem here between you and Ms. Hall that escalated, and at least from your ability to control your actions got out of hand, and those things happen in relationships, but people have all kinds of things that go wrong in relationships, affairs. That happens every day. That it's not a unique or a new story. Not everybody does the kind of things that you've done. And so that tells me that there's some additional underlying issues there with you that need to be addressed, and I think you are addressing them, and I hope that you continue to do that. I think what Mr. Vernon and yourself have said, focusing on co-parenting and focusing on what's good for the children, not what's going on between you and Ms. Hall, is absolutely correct. I think that's the kind of point of view that's going to help you move past that, not have a repeat of these kind of incidents. I think a probation is appropriate here. I think some supervision to make sure that you stay on the right track, particularly given the issues that you've had during the pendency of this and other cases, will help you stay on track. It gives me and the court and the community, and probably Ms. Hall as well, some assurances that there aren't going to be more repeats of this kind of behavior. I do think that a period of jail is appropriate to address your wrongful conduct, punish you, so that you understand that this isn't going to be tolerated, that it's behavior that has consequences to you directly. It's unfortunate that it affects your children as well, but those are their choices that you've made and actions that you've taken that having that effect. I think it's also important for the deterrent effect. These kind of situations can go from bad to worse really quickly. It result in serious injury or death. The spouses, when people don't follow court orders, when a court order isn't enough to control the person, it gives law enforcement, the victim, everyone involved in the case, concerns that that person isn't going to stop at all when they know there's a court order in place, and that doesn't prevent the conduct. So I think the community as a whole needs to see that when there's an order in place, when there's not supposed to be contact, when there's a situation like this, if the person has to obey those orders or again, face some consequences. And that's again for the safety of the people involved. So for all of those reasons, I think a jail sentence is appropriate. The court could sentence you to almost 2 years in prison for this. I don't think that that's warranted under all the circumstances here. I think a sentence at the low end of the guidelines will address the issues of punishment for you and deterrence. And I think the recommendation is appropriate. It's at the low end. I think it adequately addresses those concerns of the court, along with the probation. The probation is going to start out as a lengthy term, but you do have the ability to cut that term in half. If you're in compliance, things are going well, there's no reason why you can't be released from probation significantly sooner than what the court has ordered.
Judge, there are restrictions on some offenses and aggravated stalking as well. It's unfortunate.
Okay, so there isn't any.
There would not be.
Okay. All right. So I was wrong about that. I forgot about the charge in this case. So the probation isn't going to be something that can be shortened. Yeah, so making sure that having a sense of security for Ms. Hall, even though she expressed that she's not worried about that. As Ms. Koch indicated, that's something that's got to be worked. So the court is going to follow the recommendation. I find that it's well tailored to the situation here and sentence you to probation for a period of 5 years. The court is going to adopt as the conditions of the probation all the terms and conditions listed in this report. Where it's going to order you to serve 11 months in the Crawford County Jail. You do have credit for 40 days served. Crime victims assessment $130. Court costs of $325. Attorney fees of $350. $68 state costs. $30 per month supervision fee while you're on probation. Those all apply to the aggravated stalking charge. As to the domestic violence second, the court is going to order 6 months in the Crawford County Jail with credit for 40 days served. That time to be served concurrent with other sentence and a $50 state cost. You have the ability to seek an appeal of the sentence. And Mr. Vernon, have you been able to go through color rates with Mr. Long?
I did. I went through them. He signed the receipt. The court has the signed copy. He has two. Prosecutor has one.
Thank you. Mr. Law, you are handed to the custody of the county.
I have one question with regard to the sentence before he left.
Yes.
Based on the statement that Mr. McFarland just made, the first paragraph of the recommendation appears to be inconsistent. It identifies with the second sentence that the defendant would be eligible for early discharge provided they have completed at least 50% of the community supervision and met rehabilitation goals. Would it be appropriate to either strike that or one of those things ought to happen? It either be allowed or struck.
Right. So Mr. McFarland, you're indicating the statute does not.
That's mandatory 5 years probation, aggravated stalking.
Okay. So we'll strike that portion of the PSI then.
That's the only question I had thinking on.
And it's 11 months, not 6 months.
It's 11 months jail. And you get credit for 40 days. Okay.
Thank you, Mr. Vernon.
Take those with you.
That hearing had a little bit of everything. The first case, People v. Jamie Barto, was straightforward but telling. Judge George Mertz handled it with his usual measured approach, granting Barto probation under Michigan's 7,411 statute essentially, a second chance provision that keeps the conviction off the record if probation is completed successfully. Both the prosecutor and defense agreed with the recommendation, noting Barto's minimal criminal history, his role as a stay-at-home step-parent, and the absence of any distribution-level involvement. It was a personal use situation. The judge made it clear, though, that probation was a privilege, not a free pass. If Barto violated, jail would be on the table, and the court wouldn't be swayed by financial or caregiving arguments at that point. Then came People v. David Law, which carried more tension. Law was being sentenced for aggravated stalking and a domestic violence second offense, with a history that, while not extensive, had quickly escalated. The prosecutor pointed out that even the victim's letter in this case echoed sentiments from a prior incident concern, but also reluctance to see him punished harshly. Defense counsel urged a sentence at the low end of the guidelines, focusing on Law's commitment to better co-parenting and developing healthier decision-making tools. Law himself promised the court he'd never be back, emphasizing his desire to focus on his children. Judge Mertz was candid. He'd presided over multiple hearings involving Law and knew the backstory well. While acknowledging Law's lack of a deep criminal history, he stressed that ignoring court orders in cases like this can quickly lead to dangerous outcomes. He ordered a substantial sentence, 5 years of probation, with 11 months in county jail, credit for 40 days served, citing the need for punishment, deterrence, and community safety. The judge also struck an incorrect note from the pre-sentence report that suggested Law could be discharged early from probation, clarifying that the statute for aggravated stalking doesn't allow it. The courtroom tone shifted between supportive and cautionary probation in one case, with a clear path to dismissal and a stricter, safety-focused approach in the other. Judge Mertz managed both with clarity and firmness, leaving each defendant with no doubt about the seriousness of their obligations moving forward. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.